Community once again. Um, there are certain portions of Mr. Amoy's submission that I side with, but there are certain portions I disagree, humbly so. So when I got to know that this is what we are going to talk about this morning, I tried to do a little research on that because I'm not a lawyer, neither am I a student of law and all that. I'll do more reading. And then, so plea bargain in Ghana came about in 2010. 2010. What the law says, the legal basis, Criminal Procedure Amendment Act 2010, yes. Act 796. It added section 237A to 237F into the Criminal Procedure Code 1960, Act 30. What it allows: the prosecution, accused person, or sometimes the victim, complainant, can negotiate an agreement before trial ends. The accused agrees to plead guilty in exchange for concessions. The second point, how it works. There are 3 steps. Negotiation first. Prosecution, the accused and the lawyers discuss. Victim can be consulted for compensation or restitution. The second is agreement. If they agree, terms are written down. Common terms: accused pleads guilty to a lesser charge, or prosecution recommends a lighter sentence. The third step, court approval. The judge is not bound. Court must be satisfied the plea is voluntary. And then accused understands the charges and agreement is in public interest. Judge can reject it or even order full trial. The keys you should know: 1. Rule or details. It must be voluntary. The accused must plead guilty freely, no threats or force. The charges can be for lesser offense or some counts dropped. The sentence, prosecution can recommend reduced sentence, but judge decides final sentence. The record, agreement must be in writing and read in open court. The victim's view on compensation or restitution must be considered. Withdrawal, if court rejects deal, accused can withdraw guilty plea and go for full trial. Offenses that cannot be plea bargained. It's not everything that you can go for plea bargaining. Act 796 excludes some serious offenses. Plea bargaining is not allowed for murder, treason, genocide, piracy, robbery, rape, defilement. These things, when you do, you cannot go for plea bargaining. Offenses punishable by death. If whatever you have done at the end is punishable by death, you cannot go for plea bargain. Any offense involving public office or property where accused is a public officer, except with AG's consent. So even with this, one can be an appointee or a former appointee or have something to do with the government. Yet it is subject to the Attorney General's consent. we can go on to say, why is stealing causing financial loss to the state, money laundering, like in the Sedina Tamaklo case, can be plea bargained if AG agrees? I know the past week we've been talking about Sedina's case. Why Ghana introduced this? Now, this is very important that we must all note. Okay. To reduce case backlog, okay, courts are clogged. Plea bargains have saved time, save cost, less time, less money for state and the accused. Victim compensation. Victim can get restitution faster. The fourth point is that prison congestion, fewer long trials, less remand time. Bottom line, in Ghana, if you can bargain, it's not like US movies where prosecutors make deals freely. The judge has the final say and serious crimes are off the table. So, this is the history behind it. Now,